Maddox, and thank you for allowing us time to speak. My name is Shannon Loyd, and I'm here on behalf of the Texas Travelers Association, and also on behalf of myself as a first-party insurance practitioner in Texas. I'm going to try to honor what your request was earlier this morning and stick to issues that haven't been overly argued. I do want to point out that in the last few speakers I've heard, like Mr. Watts saying that the provision is overfair, somebody else saying that policyholders can understand and that we are somehow, we the opponents of this bill are somehow disrespecting their intelligence. As a policyholder lawyer for the past 10 years, I can tell you that I have had many clients who would not be able to understand this provision and how it works, and who do not understand how arbitration works. You guys heard this morning about these Texas, the farm and ranchers policies with the arbitration clauses. Some of those were my clients. My clients had no idea that those were in the policy. And when we explained arbitration to them, they still didn't understand it, even when we explained it to them. And after we lost the first few arbitrations and explained to the subsequent clients the possibility of winning an arbitration, they chose to accept what we lawyers consider a nuisance value offer of settlement from the insurance companies. So that's a practical effect from an actual practitioner. Now, a couple things I want to talk about. Obviously, I, on my own behalf and on behalf of the Texas trial lawyers, are here to ask the department to reject this endorsement. This endorsement is not optional in practicality, because there's no consumer that can really grasp the concept of arbitration and the ramifications of waiving their constitutional right to a jury trial while they're filling out their application for insurance. I've heard people say that they're being handed this piece of paper that explains how this whole process works in the disclosure sheet. But in the reality, in the real world down in South Texas, what will happen is that a couple will come in and talk about insurance with the Farm Bureau captive agent, not an independent agent, and he or she will hand them the disclosure, and they won't read it because he or she will tell them, here's this great deal I can get you this money off of your policy, your premium, you can save a bunch of money, it's cheaper and faster and better than litigation. That's going to be the practical effect of what happens with this disclosure form. I represent many small business owners, and many of my clients over the past 10 years, my case with them has been the first claim they had ever had. And the reason why no disclosure on arbitration could ever work effectively with an insurance policyholder is because until they've been in a claim, until they've been in a dispute, they have no idea what the practical effect of this arbitration clause is. I've heard proponents of this endorsement talk about some attorneys having an arbitration clause in their attorney fee contract. I do not have such a provision in my attorney fee contract. But I will say that, and you, Mr. Maddox, you know this as an attorney, if you or I are sitting across from our client talking about our agreement, we have a fiduciary duty to our client. Whether and whatever the Supreme Court has said or not said in the case that has been cited, we know we have that fiduciary duty to explain this. And in addition to that, that client does not have to hire you or me. They can go find another attorney if they want to. If this endorsement is allowed and all the other carriers follow suit, which they will, there will be no other options for these policyholders. And so insurance companies, by law, have no fiduciary duty to their policyholders. They do, however, have a fiduciary duty to their shareholders. And we believe that's where this is coming from. Now, this morning, I heard the Farm Bureau representative say, this is going to be easy for policyholders. It's going to be easy for them to prove their case. And in fact, the actual provision in the endorsement says that the policyholder and the insurance company will present their evidence to the arbitrator and present their arguments. And here is the practical effect of this. You you have a policyholder versus an insurance company. All the insurance company does is coverage. The policyholder doesn't understand coverage the way the insurance company does. You have a severely disadvantaged party in attempting to convey evidence and argument to this arbitrator with regard to coverage. Mr. Longley was not saying this morning that 541 and 542 and other extra contractual protections were not available in arbitration. What he was saying was the average policyholder, even a small business owner, doesn't know how to make those arguments. The average policyholder does not know how to argue improper claims handling. And that was his point. I have had nearly every one of my small business owners tell me, Shannon, they accepted my policy premiums. How can they now say that my roof is old and that's why it's damaged? Well, that's a great justice argument from a consumer perspective, but we know, and you know this, Mr. Maddox, that's not a policy argument, and that's not a policy, that's not a defense to the exclusion that the insurance company is trying to apply. But that's what the policyholder is going to argue. So they don't have the requisite knowledge, training, and experience in insurance and coverage the way the insurance companies have. And here's a great example. What do we do when we have a case where there's a theft or an arson? And I know it was discussed a little bit this morning, but let's look at the other side of this. If we have a theft or an arson and it goes to arbitration, what if the insurance company says, we think you did this. We think you, the policyholder, started this fire. We think you, the policyholder, pretended that you had your stuff stolen and you really didn't. That's an allegation of fraud. So now not only is this policyholder trying to get their claim paid through the arbitrator, now the policyholder is having to defend themselves from an allegation of fraud, which is a crime. What does the policyholder do then when they're in arbitration? You're having an arbitrator decide whether this policyholder has committed a crime. John Black spoke this morning before lunch very eloquently. He's a great speaker. He talked about how, as an attorney, he'd have trouble getting discovery in arbitration. But I want to talk to you, lawyer to lawyer, about the practical effect of arbitration. The practical effect is the policyholder won't have a lawyer unless they can pay $1.50 the hour. I told you I represent small businesses, a lot of small businesses. I'm a small business. Part of what I have to do is make sure that my time and my firm's expenses are put to good use. I have to earn a living just like everybody else. And I know, and we other policyholder lawyers know, and CTLA knows, the practicality is that consumers lose in arbitration. I'm not going to go through all the statistics with you because you have those and I'm sure you've heard them ad nauseum. But as a lawyer evaluating a case, if I know I don't have a chance to likely recover for that client, it's not a good business decision for me to take that case. So what happens is we'll have an insurance company who at a minimum has a claim manager, but will probably have an attorney representing them in the arbitration. And your policyholder will have no one representing them. Because most policyholders, even small business owners, cannot afford to pay a lawyer by the hour. Earlier, you heard about all the case law saying that it's not unconscionable to have an arbitration provision in a contract. I'm not going to go over all that case law, except to say this. The case that you heard about twice today, the oil shale case from San Antonio, that case actually held that that consumer, because of the cost of the arbitration and because that consumer sufficiently proved what he would have to pay for arbitration, that provision in that contract was unconscionable. And so we have had courts say that arbitration clauses are unconscionable. And so that leads me to talk to you guys about the cost of arbitration. I know we've talked about how Farm Bureau is going to pay the arbitrator, they're going to pay for the arbitration. That's not all the cost. And this goes back to trying to have this poor policyholder prove their case to the arbitrator. The insurance company will have licensed adjusters' estimates. The insurance company will likely have reports from engineers or from building consultants? How does the average policyholder go to the arbitrator with evidence to disprove or to counter that evidence? What they have to do is they have to go out and hire an engineer. They have to go out and hire a building consultant if they want to be on the same footing. But guess what? Most of them can't afford to do that. And so they will either not go forward and drop it because they can't afford it, or they'll go forward and they'll have an unequal, it'll be totally unequal and unbalanced, because the insurance company will have all the experts, they'll have the attorney, and the policyholder will not. And I'm just trying to speak to you from a practical effect of someone who's been doing this for over 10 years. This is the practical effect of this arbitration provision. Mr. Brin said a moment ago that when it comes to picking the arbitrators, the policyholder and the insurance companies are on equal footing. I think he said equal footing. They are not on equal footing. The average policyholder doesn't know who these arbitrators are. They don't know how to pick an arbitrator or what makes an arbitrator good or bad. They don't know how to research an arbitrator's background and how they've ruled in other cases. So it's not an equal footing. The constitutional right to a trial by jury is the main reason we would ask that the department reject this endorsement. But here's another reason. There's already safeguards in place, and those safeguards are under the law. The insurance code has a counterclaim for frivolous lawsuits, and people have already spoke about that. The Texas Rules of Civil Procedure allow, now this is a new thing, 91A allows you to file a motion to dismiss. And if you're successful, because there's no basis in law and fact for the case, you get your attorney's fees and you get costs of court. There's also Rule 13. I, as a lawyer, if I sign a petition that I know is not appropriate, not valid, has no basis in law and fact, I can be sanctioned. Those are safeguards that are already in place under the law. There's the Texas Penal Code with fraud. There's the Barratry statute. TTLA has always been a proponent of strengthening the Barratry laws, and it has always been a proponent of stopping the bad actors who commit Barratry. The last safeguard I want to talk about is the new public adjuster bill that was passed in the last session. It's 4102.103. And what that bill says is that a public adjuster cannot sign up a client unless they have the intent to actually work the claim. And we know in the Valley there was a problem with some public adjusters not working their claims. And so this statute was passed just last session. And I know that the Farm Bureau representative gave you statistics for the 2012 hailstorms, and then he gave you statistics for the 7 months ago, the Rowlett tornado, the Wiley 4-inch hailstorm, and he gave you those statistics. But I want you guys to keep in mind that this PA statute was passed in between those 2 sets of storms, or 3 sets of storms. And so to what extent did that have something to do with the lesser litigation up in Wiley and up in Rowlett? Which leads me to my third reason we would request that the department reject this provision. We should have more time to look at this issue. We should have more time to look into the data. I know that the data call that was made, the data is due in August. We would like to see some of that data. We would like to see how the Farm Bureau numbers that were presented today, we'd like to see those on paper. We'd like to see whether Farm Bureau has ever utilized the safeguards that I just spoke of under the insurance code, 91A. Have they ever tried to utilize those safeguards? There's some issues, these are the same issues that we're talking about today that were argued contentiously in the last legislative session. And I think that we're going to see them again this next session. And Mr. Maddox, the last thing I want to tell you is this. This provision, this endorsement, this is not some cosmetic exclusion for a metal roof. This endorsement has far-reaching implications to people's constitutional rights. And I would again say, if the average policyholder cannot be put in a position to make a decision, such a far-reaching decision, when they have no idea and have never been in a dispute before. And so they have no idea what to expect. I want to, again, thank you for letting us speak. I would welcome any questions if you have any, and again, we appreciate the department allowing